right, we'll go on the record in Godiva versus Rutcamp. We're on the record here today. Ms. Bailey Quick, you filed a motion for exclusive possession of disputed premises. I did have a chance to review your motion as well as Mr. Blumberg's response. Ms. Bailey Quick, anything by way of oral argument that you'd like to raise here today?
I did have an opportunity to review Mr. Blumberg's motion and response. I do believe, if the court wants me to brief it, I unfortunately did not have, I did research the issue. I do believe that the statutes as well as court rules contained in my motion comply if the court wants a separate brief. There's nothing required in the court rules themselves that require a separate document per se of a brief, but if the court would like that, I'm happy to do that. I would just like to note that I did have an error as to the address of the property. It is 4844, not 4484. And so I just wanted to point that out as well. Additionally, the sum and substance is that there's repeated statements throughout Mr. Blumberg's response and his brief that essentially Mr. Rutcamp and Miss Elcorne are preventing Miss Godiva from accessing or coming to the property. And that's just frankly not the case. I think the court probably has sufficient information at this point related to the history and the parties that it is Miss Godiva's actions on her own behalf that have prevented her from accessing the property or being allowed at the property. There is multiple personal protection orders. There's been criminal actions. It's her actions alone that have prevented her from being allowed at the property. And so, yes, although I acknowledge that the parties are joint tenants in common, and by definition, they are both entitled to full access of the entirety of the property. If we were talking about individuals that didn't have any other barriers like personal protection orders or in the past criminal bonds or other issues. However, that's not what we're dealing with. What we are dealing with is individuals that have other barriers, and the continuous litigation created could be alleviated with an order until this case is resolved. We need some resolution. These parties cannot and will not be able to live harmoniously at this property. One party will have to ultimately buy out the other property, and this is the only place that the minor child has ever resided, and that's ultimately what's before the court. And we are just asking, until this case is concluded, to essentially grant exclusive use to my client, given the very contentious and litigious actions, and that would hopefully put to bay involvement of multiple other courts involved, so that we can get a resolution, whether that's soon, hopefully, that we can finalize this case, or whether it's 3 months from now or whenever that is. But this would, I think, help give some finality and an assurance to everybody involved, and reduce the number of additional litigations being involved.
Thank you. Mr. Blumberg?
Well, Judge, I think, again, I apologize for the late filing of our response to this motion, but the court, as you know, in Gaylord, we were out without power for a significant period of time. So if we were in front of Judge Burmeister earlier today on the eviction proceeding against Miss Elcorne. Miss Elcorne is a resident of this property as a guest of Mr. Rutcamp. She is not a tenant. She has no legal right to be there. Consequently, my client has been prevented from entering this property since 2022, when this fraudulent lease was prepared by Mr. Rutcamp, which effectively kept my client out based on a PPO that Miss Elcorne had obtained against Miss Godiva. Mr. Rutcamp is the recipient of a PPO. He can't be in the same proximity with my client for almost 2 years, based on Judge Burmeister's ruling. So yeah, there is a high level of contention between the parties, but contrary to counsel's representations, this wasn't all brought on by my client. It's by the duplicitous actions of Mr. Rutcamp. Once Miss Elcorne is evicted by virtue of the district court, then my client will have access to that property. The PPO that Connor has expired. There is no PPO in place between the child and the child's mother. There is a custody proceeding moving along in Judge Burmeister's court. So this motion is so ill-conceived and based on no legal authority. I mean, there is reference to a temporary injunction, and yet the pleading doesn't even state what the court is required to go through in determining whether a preliminary injunction is appropriate. I have asked the court to not even hear this motion because the court rule clearly requires whenever there is an issue of law that's presented before the court, it is required that a brief be filed. I don't believe under any reading of this motion could the court consider this to be a brief. You are given no guidance as to the authority for the relief that you're being asked to grant in this case. We are asking the court to deny this motion. Once Miss Elcorne is evicted from the property, then my client will have access to the property that she owns. Part of this lawsuit, Judge, is a claim for ouster. My client, an action that we originally brought in the district court that Judge Burmeister removed or told us we had to bring in circuit court. Ouster is a claim where one joint tenant takes actions to cause the removal of another co-tenant unjustly or without any legal authority. And that's what's before the court. It's not just this partition action that was an afterthought filed as a counter complaint in this case. Again, I don't believe that there's any authority for the relief that you're being asked to grant in this case. And candidly, I take exception to the manner in which this matter was brought before the court without any authority for the relief, with no brief filed, no affidavit. It's an unverified motion. We just think that it's improper for the court to grant this. We would ask the court to deny the motion, allow the eviction process to continue in district court, and then we'll continue to litigate this matter to its conclusion before you. Thank you.
Where is the eviction process at, Mr. Blumberg?
Well, as of this morning, I was certainly of the impression, because Miss Bailey Quick asked the court for additional time, which I happily offered her, because in the eviction proceeding, Mr. Rutcamp and Miss Elcorne are claiming that she is a tenant, a holdover tenant. There was a lease that expired, and she continues to reside there. By her own admission, Miss Elcorne's own admission, and Mr. Rutcamp's signed pleading, they both acknowledge she is a guest. And as a guest, she has no legal entitlement to be in that property. And I think Judge Burmeister candidly is going to find the same way. It's my feeling that she will be evicted fairly soon.
Judge, may I respond?
Yeah. Yep.
So I had filed a motion for summary disposition in the eviction proceeding, and I received a response yesterday, which is why I was given additional time to be able to review that with my client as well as respond to that. Contrary to Mr. Blumberg's position, I believe that Judge Burmeister has no option other than to dismiss the eviction proceeding because it was improper. Notice was improper, and whether Miss Elcorne was a prior tenant. Yes, she has stated that she has remained on the property as a guest. However, she pays for certain items. She caretakes at the house. She does certain item or certain things, and by virtue of all of that, she is a tenant by conduct, and that requires a 30-day notice to quit, which was not afforded. And that is the opportunity in which I get a chance to respond to. And so I believe, based on all of the law, again, and the improper notice, that that Judge Burmeister is likely going to dismiss the eviction proceeding.
Well, do you
Again,
guys have a next hearing date in front of Judge Burmeister, or what is?
no, he gave me 7 days to review the response and file my reply brief.
And then he's gonna issue a written opinion, is that, I'm just trying to get a sense of the procedural posture of that case.
Right. Yes. He said he would issue either a written opinion or bring us back for hearing.
Okay,
That's correct.
okay.
Your Honor, there was statements made that there was a lease in 2022 for Miss Elcorne, which is not the case. And that it was something done by Mr. Rutcamp alone, which is again is not the case. And that it was only because of that Miss Godiva hasn't been allowed at the property, which is again also not the case. And it is my understanding that there is a motion to extend Connor's personal protection order in Otsego County. I'm not involved in that. I don't know the status of that. That's just what was brought to my attention. So that may continue prohibiting Miss Godiva from entry on the property. Initially, she was barred from the property because of criminal proceedings that both of the parties were facing. It wasn't because of Miss Elcorne. It was Miss Godiva and Mr. Rutcamp. Both of them were prohibited from being at the property. She then agreed for Mr. Rutcamp to go back to the property. And so, I just want the court to be aware that several of those statements were just not accurate.
All right.
Hey, Judge, I don't know if
Well, I just have a question, Mr. Blumberg. Is it fair to say that as long as Miss Elcorne has not been evicted from that property, that your client is prohibited from going there based on the PPO?
Yes.
Okay. So I think there's a number of issues here. I think, first of all, I tend to agree with Mr. Blumberg, especially if the request is for some type of injunctive relief to prevent Miss Godiva from accessing the property. That's an extraordinary relief, as the parties are aware, and I think it would have to be, any request in that regard would have to be in strict compliance with the court rules governing injunctions. And Ms. Bailey Quick's motion clearly does not comply with the requirements under the court rule for injunctive relief. And I kind of took Ms. Bailey Quick as your motion as kind of a mixed injunction, invoking the court's equitable powers to maintain the status quo, so forth. But it was less than clear. And I think if the court is going to prohibit a party who otherwise, outside of the PPO, as you said, outside of any other circumstance, would have a legal right to be on that property and access it, I think I would need a much more clear basis for which you were requesting the court to order her to not have access to it. In addition, as Mr. Blumberg just acknowledged, and I think both parties recognize, is as long as Ms. Elcorne has not been evicted from that property, Ms. Godiva can't access it without violating the PPO anyway, which I'm sure counsel has advised her not to do. So the court finds that even if I was looking at this from the standpoint of an injunction, there isn't that kind of immediate or imminent threat of a problem here that the court would have to find, because there are other orders preventing Ms. Godiva from accessing that property. So I think two things would need to happen, Ms. Bailey, quick, before I can grant the relief you're requesting. First, I think it would have to be more fully briefed and supported by affidavit. And I think there would have to be a clear statement of what powers you were invoking the court to exercise. And then Mr. Plumber, of course, would have an opportunity to respond. And I think we would have to have a situation where there wasn't any other prohibition from Miss Godiva from accessing the property if the request is made as an injunction, because again, I think there would be an issue with the immediate, imminent, and irreparable harm element, which is arguably the most important element of an injunction. That doesn't mean that there aren't other, there wouldn't be another basis such as status quo or maintaining peace or something like that. Maybe that some other type of mechanism that you could invoke the court's equitable powers to exercise outside of an injunction. But either way, I don't think I'm in a position to be able to grant that relief as it's been presented. So the court's going to deny the motion without prejudice. And Ms. Bailey Quick, you're free to refile at such time as Ms. Elcorne is evicted and the PPO is not going to prevent Ms. Godiva from accessing the property, or you have a clear statement of the basis for the court exercising its equitable powers. So Ms. Bailey Quick, if you can prepare an order that reflects the ruling of the court today and submit that under the 7-day rule. And then we'll see where we go from here. That's all I have for today. Both counsel are free to disconnect at this time.
Thank you.
Thank you.